Jonathan Lee Riches Investigates. I am covering the Michael Vaughan case out of Fruitland, Idaho. I want to share with everyone today about Stacey Wondra. Stacey Wondra. He is the husband to Sarah Wondra, who is currently in custody in the Fayette County Jail, charged with failing to report a death in relation to Michael Vaughan. Stacey Wondra. I was able to obtain a handwritten letter that Stacey Wondra submitted to his judge, claiming he is 100% innocent of his charges. And when I say charges, I mean he was previously charged with a gun charge in federal courts, and he pled guilty and got sentenced. But he wrote to the judge and then claimed he was innocent, and he didn't do it. And it provides a little bit of insight about his character and about his thinking process. You accept responsibility, and then he reneges on that. So I'm going to share with you right now a public court document that I was able to obtain, and then we will discuss a little bit further. Check it out. So here is a handwritten 2255 post-conviction relief motion by Stacey James Wondra. He submitted this to the courts while he was in federal prison in Sheraton, Oregon, serving time for his probation violation. He originally pled guilty to false statement to acquire a firearm. I will read this. I want to share with you here, right here. So, Wondra claims ineffective assistance of counsel. The lawyer was ineffective in this case and failed to serve his client, violating due process and equal protection under the Constitution. The defendant has serious medical issues. He has autism, Asperger's, explosive disorder, bipolar, and was born with fetal alcohol syndrome. None of these issues were raised in the court, which would have led to the dismissal of charges against him. So he's claiming the medical conditions that he has would have led to charges against him being dismissed. And he's citing Strickland versus Washington. The defendant was coerced into a plea. It was unknowing and involuntary in his mind, as he is not capable of processing the complicated law required to make a rational decision or choice. Further, a panel attorney was appointed, and within 2 months of plea was signed. The lawyer lied and misled the defendant, telling him he had no chance to win, and if he did not sign, now he would be sentenced to more than double time. He was afraid, and no attempt was made to correctly and morally advise him of his rights and chances to have his case dismissed under various issues the writer has found so far. The defendant was not giving access to discovery that even showed a background check was completed by the pawn shop registered seller over the phone before the sale took place and was approved. This counsel was ineffective for failing to raise mental illness claims before the court. Counsel made errors so serious as to deprive the defendant of a fair trial. That deficient performance prejudiced his defense. Double general principles, the handwriting's very hard, should be applied besides Strickland. This is an unreasonable argument to grant claims of ineffective assistance of counsel. Assistance here is constitutionally deficient because counsel is aware that the defendant, 400-pound frame, crossed eyes, was visible from some distance. It does not take a doctor to instantly realize great problems exist by sight alone, and only several minutes of verbal conversation conclude there is a great problems. He is emotionally and mentally unstable. He is ill and depressed and borders on invalidate status. His treatment while incarcerated have not improved his situation, and immediate action by this court. To release him is required without delay and in the interest of justice. Strategic choices made on the defendant's behalf by counsel were unprofessional. Counsel failed to make reasonable investigations for which counsel has a duty to perform. A reviewing court must make and apply a heavy measure of deference to counsel's judgments about not investigating anything at all and other poor choices made on the client's behalf. The defendant has shown his own counsel was deficient and is unquestionable counsel's deficient performance prejudiced his case and resulting sentence when he was not guilty of anything. The defendant's Sixth Amendment ineffective assistance claim should be granted and his case dismissed. Counsel failed to investigate and obtain prior medical records and argue diminished capacity. Plaintiff did not make a false statement, so he's denying he made a false statement on his case. The defendant at no time made any false statement on the form provided by the seller, and the government under 922 or 924, the required form is 4473. A mistake was made when, after having a federal charge and a state charge changed to a misdemeanor, which would not restrict the purchase of a firearm, was not corrected in the government's computers. Statutory interpretation begins with the plain language of the statute. If the plain meaning of the statute is unambiguous, that meaning is controlling. Here, the question was in Form 4473, are you any charges that you prevent you from buying a firearm? He answered no, which was correct. The question continued, would your sentence be over a year? He said no. The history of this case is that the state of Montana charged the plaintiff with burglary. It was later dropped to a misdemeanor. Shortly after the new plea, he bought a gun on March 14, 2018 for $375. He stated above he correctly filled out 4473 forms and underwent a verbal phoned-in background check at the pawn shop seller. He possessed and was cleared. 5 days later, his car broke down and he needed the car for work. He sold the gun back to the pawn shop for $325 to fix his auto that took him to work to support his family. 90 days later, while driving home from Reno to go to work in Montana, he was pulled over and arrested. He was pulled over and arrested. He had done nothing wrong, and a computer error of the government left him in this mess. Under ordinary rules of statutory construction, courts presume that Congress acted intentionally when it chose to include the word material in 18 U.S.C. 922 A.B., but to omit it from 18 U.S.C. 922 A.1a, which is part of the same act. Here, the court should have given meaning to the difference in congressional intent. It failed not to, so as this conviction should be overturned. The government failed to prove that the sale and form out of 4473 had falsehood related to the lawfulness of the sale. The case here does not criminalize a broad range of false statements. Actionable falsehoods are only those statements required under the law to be kept under the federally licensed firearm dealer. No statement alleged was in that category. The federal seller must keep name, age, and place of residence of all buyers. The best of the info was cleared in the telephone background check to the federal government, who okayed the sale. That is the end of it, and any charges should be investigated by his counsel. They were not, and the defendant was suffered at the hands of an ineffective lawyer and a faulty government computer system. And then here's some more forms. And then this is my first appeal on all issues. My sentence was April 4, 2019. There it is. Stacey J. Wondra, Sheraton, Oregon, Sheraton Prison. Here's an affidavit that he submitted. I swear under the penalty of perjury. I sent a copy of the attached motion to the U.S. Attorney's Office in Billings, Montana, signed by Stacey J. Wondra, 3/7/2020. This is a public court record. Anyone can obtain the same record by going onto the PACER system. This is a post-conviction relief motion that Stacey Wondra filed with the courts, United States District of Courts. He claims he is innocent. He claims ineffective assistance of counsel. He's claiming he did not do his crime. So that came from Stacey Wondra. Some of the handwriting might be his, some of it might not, but it's handwritten, signed by him, an affidavit at the end by him. He submitted that to the court, saying he's innocent. He wants, he wants to get out of jail. Ultimately, the judge, Susan Waters, a federal judge out of Billings, Montana, denied that motion. It was a 2254. It's a post-conviction relief that inmates can ask for that are sentenced after they exhausted their appeal process. So he was trying to proclaim his innocence, even though he pled guilty. He claimed ineffective assistance of counsel, said, his counsel was at fault here. What do you think? What do you think? Because he's currently in custody again right now, unrelated to Michael Vaughan that we know of, but he is in jail right now in custody in the Washington County Jail, which is about 30 miles north of Fruitland, Idaho, and he's charged with, again, felon in possession of a firearm. So this is his second time he's now been arrested for that type of crime. Is he making a deal with prosecutors? Did he flip on Sarah, his wife? Did he flip on others? Is he cooperating? I know I recently read some of his newer court documents. He just changed it attorneys, and he is in plea bargain negotiations. I'll make another video about that. But subscribe to my channel, hit the notification button. Authorities right now are searching his property, the property belonging to him and his wife. It belongs to, I believe, Sarah's family, and they are tearing the property apart, digging it up, sending dogs through. They've been doing it for days. They're looking for Michael Vaughan on their property. I got a lot of videos on the Wondras, so check them out. I'll keep you posted. Hopefully Michael Vaughan is found soon. Hopefully the people responsible are held accountable. Praying for Michael Vaughan's family, praying for the community of Fruitland, Idaho. Talk to you soon. Justice for Michael Vaughan.